A Minnesota woman was shot and killed after simply saying no. 22-year-old Kayli Arseth met a man online. The two had been spending time together, but when he allegedly wanted more, she turned him down. A day later, her family requested a welfare check, and police found Kayli dead inside her apartment. The man she reportedly rejected is now behind bars, accused of murder, and he's facing life in prison. Thanks for joining us. I'm Kennedi Walker, and I'll walk you through the details. You're watching Law and Crime. Kayli Arseth's loved ones describe the 22-year-old as vibrant, full of life, quick to laugh, and always smiling. But now her smile only lives in memories, and her laughter is silenced by violence. Police say Kayli was killed inside her Minnesota apartment after reportedly rejecting the romantic advances of a man she met online. Court documents reveal Kayli had recently been spending time with 27-year-old Jose Lopez Chique, but when he allegedly began pushing for a romantic relationship, she turned him down. In a message sent on June 16th, Kayli wrote, "I did enjoy hanging out with you, but I don't have enough mental capacity for any type of relationship right now. I'm trying to figure out myself as well as manage my relationship with my parents, and I'm overwhelmed and stressed already." Investigators learned that hours before she sent that message, Lopez Chique allegedly purchased several items, including gloves, tape, a mask, and an apron. Later that afternoon, around 3:30 p.m., his phone reportedly pinged outside of Kayli's apartment. He was allegedly texting her from the parking lot. About an hour later, a neighbor reportedly heard Kayli yelling, "How could you do this to me?" followed by a male voice. Minutes later, they heard someone leaving, but they didn't see who it was. Kayli never met up with her friend that night, and when she failed to report to work, her family requested a welfare check. That's when police found her body inside the apartment, along with signs of a violent struggle. Later that same evening, Lopez Chique's phone reportedly pinged again, this time in a different location. Police searched the area and found 2 bags of discarded items, including 16 rounds of ammunition. When officers arrested him near his home, he didn't ask why, instead telling officers to hurry it up, according to the criminal complaint. Inside his home, investigators say they recovered a firearm. They also noted scratches on his chest and puncture wounds on his forearm. While in custody, Lopez Chique allegedly told investigators he wasn't going to answer questions, but added they could keep talking and maybe something will slip. He then reportedly requested a lawyer. Lopez Chique has been charged with second-degree murder. His bail is set at $2.5 million. And here to break down this story with me is criminal defense attorney Joe Tamburino. Joe, thank you so much for coming on today.
Thank you for having me on.
So let's just jump right in. The suspect has been charged with second-degree murder. Why not first degree?
Well, because with first degree, they have to go to a grand jury. Now, you raise a good point with that question. Why not first degree right out of the chute? In Minnesota, the prosecutor could do that, and I'm surprised that they didn't. You'd have to contact the Hennepin County Attorney's Office. A prosecutor can charge first-degree murder, and then they basically have 2 weeks to impanel a grand jury to go get first-degree murder by indictment, which means natural life. So you are right. Why didn't they? I don't know. They should have, and that gives them a couple of weeks to get the grand jury started and then get an indictment on first degree. Now, since they haven't, it's not the end of the world. They can still get that grand jury indicted and start that process very soon.
Right, I was just about to ask, even though it's second-degree murder right now, it can change potentially.
Absolutely. And I would imagine it would change because based on what the complaint says, there's a lot of evidence that there was planning into this crime.
Yeah, speaking of that, with the planning, police say that the suspect allegedly bought tape, gloves, a mask before the killing. What does that suggest legally?
That shows you planning a forethought or trying to plan the crime ahead of time so that when you do the crime, you're going to try to be successful at it. You're going to try to get away with it. And all that builds up to premeditation. Premeditation means you more than just intended it, it means you planned it. And so in this case, if the evidence in the complaint is correct, they have a lot of planning evidence. I mean, supposedly on June 16th, which was a Monday, this suspect went to a mega store, some big store to buy a bunch of supplies. And he bought supplies like tape, masking tape. Why would you need that? Perhaps to tie someone up, perhaps to package things up so that they stay sturdy and you could discard them. He bought other things like gauze. Why would you need gauze? Well, gauze absorbs blood. I mean, that's what it's used for. That's why it's put on wounds. He bought other things like an apron. Why would you need an apron? Well, think about it. You need an apron so you can protect your clothes and your body from different types of matter that might, spurt on it or drip on it. And he bought other things that you would think, why are you buying this all in one day and then going to the victim's house later on or having some type of interaction with her?
Right. And then I guess like when you put it that way, just it makes you wonder even more about why it isn't considered first degree. But like how we said, things could change. In Minnesota, you guys do not have the death penalty, but in other states, I mean, I think a case like this, do you think that the prosecution would be looking at this as a death penalty case?
Yes, absolutely. Minnesota hasn't had a death penalty since it was outlawed in 1911. Our last execution, I believe, was 1906. And you bring up an interesting topic because, yes, this suspect is charged under state law. There's no federal crime here, and we don't have the death penalty. If he gets indicted on first degree murder, it is natural life, which means he never leaves prison. He will die in prison. But, you bring up a good point because as the country already knows, we had those horrific murders of our state representative, Ms. Hortman, and her husband just a few weeks ago. Now, that was a federal crime. The federal authorities have taken over, and that could be death penalty eligible, even though it's within Minnesota because it involves federal law.
Gotcha. Okay. So natural life, that's if this gets upgraded to first degree. But if it's second degree, how much time is he facing if he's found guilty?
Only about 25 years. Under Minnesota law, if you're convicted of intentional murder, under the Minnesota guidelines, you get 25 years. Now, if there are aggravating factors, could a judge sentence you more than that, up to 40 years? Yes, they could. But on average, it's 25 years.
Well, on top of, the items that the suspect bought, police also were able to track, just cell phone data. How much weight do cell phone tower pings carry with the jury? Is it considered solid proof?
Absolutely. Cell phone data is getting better and better. I mean, in some situations, they're able to locate a cell phone within feet or yards of an alleged crime scene, or within feet or yards of where the victim was found. It's that specific. And in today's world, everybody has a cell phone. Everybody keeps it on all the time. I mean, think about it. When was the last time you took your cell phone and turned it off and left it off for hours on end? Nobody does that. So, with the technology, yes, they're able to locate specific areas where that cell phone was. And of course, the owner, we would assume, was with his cell phone.
Right. And according to documents, police say that the owner, according to the cell phone data, was directly outside of Kayli's apartment when he was messaging her after buying these alleged items. I mean, what does that tell you as an attorney? I mean, just painting the picture, it seems like an open and shut case.
Yes, I think you're right. If you were the prosecutor in this case, what you would be doing is saying, I've got a great case, and I think I should go to the grand jury to get first degree murder. Because everything that's listed in the complaint, if accurate, shows that this person would have planned it, thought it out, bought the supplies, went to the location, made sure that his victim was home at the time so he could perpetrate the crime, did the crime, and then started to discard the evidence afterwards.
Police also say that Kayli sent the suspect a message rejecting him. Does that have any legal weight in establishing motive?
Yes, motive is never an element to a crime. And what I mean by that is a prosecutor does not have to prove motive. For instance, if all of a sudden somebody robs someone on the street with a gun saying, give me your money, and then runs, and they catch that guy, prosecutor just has to show that it was the right guy. He had a gun. He used it to rob somebody of property. That's it. You don't have to prove the whys or the why they did it, the motive, anything like that. But motive helps explain a crime. It helps explain a case to the jury because jurors are human beings and we all want to know, why would someone do this? Well, in this type of a case, when you have someone who's been spurned by another person, They didn't want to become romantically involved with the suspect. They wanted to keep the suspect away. That could provide some reason as to why he would do this. Now, of course, if he actually did do this, that would be insane to do that. Just because somebody, said they weren't interested in you, you would murder them. But again, it helps the jury understand why the crime was committed.
Right, because technically, I mean, can prosecutors use that just to show that he couldn't take rejection?
Absolutely, yes. And I'm sure what prosecutors and investigators are doing, probably as we're speaking here, is looking at his background. Did he have any type of domestic related offenses? Were there ever any restraining orders against him? Interviewing past romantic partners, trying to see if he was ever violent with a romantic partner. Did he ever threaten a romantic partner? I mean, they're going to be turning over every stone they can to try to see what was this guy's history, because a history could also provide you with motive and intent.
Is there any legal protection for people who are being pursued persistently but have not filed a restraining order?
Not really. You should file a restraining order. If somebody is stalking you, they just won't let up contacting you, and you don't do anything about it, really, that's no protection at all. I mean, you should do something about it. So, for instance, if somebody repetitively contacts you after you've told them, please stop, do not contact me anymore, I don't want to talk to you, but they keep doing that, you should go get a restraining order. If somebody physically assaults you or threatens physical assault, you should get a restraining order and report that to the police. So you should be doing these legal things, and they're not, it doesn't take a lot of work to get it done. Most attorneys could get it done within a day, but you should do that to protect yourself.
What does it tell you that the suspect allegedly didn't even ask why he was being arrested, but just told officers to hurry up?
Well, a lot of times that does happen. Yes, most people think as soon as an officer comes to you, you're saying, "What's up? Why am I being arrested? What's going on?" Yes, many people do that, but other people do simply just remain silent. They just don't want to talk. They don't want to ask any questions. Now, could it be used against him? Sure, sure. If there was a jury trial in this case, the prosecutor could say, "Look, based on all of you jurors, based on all of your common sense, wouldn't you inquire as to why you're being arrested? Are you being arrested for a robbery, a theft, an assault, or murder? Wouldn't you want to know?" Yes, they could use that against him at trial.
Also, police claim that when he was, after he was Mirandized and they were asking him questions, the suspect said allegedly, maybe something will slip. Well, what does that reveal from a psychological or legal standpoint?
Well, that's a little window opening into the mind of this person. Because after you've been Mirandized and after you've been told, look, you don't have to say a word and you have a right to an attorney. And, if you can't afford an attorney, we'll get you a public defender. And even after being advised of that, the person says, well, I don't want to talk because something might slip out. That's an opening in a small opening in the window of his mind, which could be argued shows that he doesn't want to incriminate himself, particularly with this murder. He doesn't want anything to slip out, meaning he doesn't want them to know what he has just done.
But technically, a statement like that, isn't he kind of sort of already incriminating himself by saying that something could slip out?
Yes, yes. See, that was something that I would consider a mistake on his part, because if you're going to remain silent, which is absolutely your right, then remain silent. You just say to the officer, I'm sorry, but I'm going to remain silent and I want an attorney. And if you do that, that can't be brought up. Your invocation of your right to have an attorney and remain silent, that's your right. So it's not going to be used against you. However, if you decide to make a statement like, I don't want to talk because I might slip up or you might find out what I did, yes, that's going to be used against you.
Now, the suspect reportedly had scratches and puncture wounds. Could that help prove that Kayli fought back?
Absolutely. And they're going to examine it in two ways. One is the physicality of it, meaning that there are scratches that could be or likely are caused by another human being's nails or grabbing. And secondly, there could be DNA, because if the victim in this case has skin cells of the suspect under her fingernails, if that DNA comes back from those skin cells as the suspect, that's going to be pretty damaging evidence.
Now, you're a criminal defense attorney. Is there ever a risk that defense attorneys will argue diminished capacity or mental instability in cases like this?
Yes, but you have to be careful. Most states, including Minnesota, does not have a diminished capacity law. You are either sane or insane. And to prove insanity, you basically have a burden to show that you didn't know what you were doing. You had absolutely no idea of what your actions were, and you have absolutely no idea what the consequences of those actions would be. It's a pretty high standard. I mean, most cases, people are not able to show that they were insane. So, yes, that could be a defense, but we wouldn't know that till later on in the case. If we ever heard that this person was getting a psychological evaluation, then we could think, well, might they be trying to build a self defense, excuse me, a mental illness case?
Let's talk more just about legal strategy and the trial process. Would prosecutors bring in a behavioral expert to testify about rejection triggered violence?
That's very difficult. You can't, as a prosecutor, just simply march up experts and say, hey, tell us why some people would kill someone else because they rejected them. That, in and of itself, is not going to happen. Now, if the defendant, what's called, opens the door to that, like say the defendant in this case testifies and says something about the rejection and how it affected him, anything like that, sure, that a prosecutor could come in and rebut that or argue against that with expert testimony. But starting in their case in chief, it's very unlikely a judge would allow simply some expert to talk about rejection in the case.
Well, tell me this. According to police, a neighbor told police that she heard the victims or that they heard the victims say, how could you do this to me?" Is that admissible as evidence?
It could be. What's going to happen is the following. In every case where you have a decedent, meaning the victim is dead, you're going to have an issue as to hearsay. How do you get the victim's statements into court? Okay, because all out of court statements are considered hearsay. For instance, Kennedy, if I was in court right now and I said, Kennedy told me this, but Kennedy wasn't a witness in the case, Kennedy's not in court, that's going to be hearsay evidence. So, how do I get it in? One of the most useful ways or common ways that comes in is what's called excited utterance. That means this: if this victim in this case said, how could you do this to me? What are you doing? So she said it in an excited state, and that's what the neighbor heard. Yes, that's an exception to hearsay, and you will get those statements in. And I think that's how the prosecutor would proceed in this case.
Well, could the defense argue, well, if you heard, Kaylee say these things, and if she seemed excited or if she seemed scared, then why didn't you call 911?
Yes, absolutely. That's something that any neighbor, witness, someone who overhears something will be questioned about. And unfortunately, in society, there's still the issue of people not wanting to become involved in other people's matters. So many times, neighbors, people who hear things behind the wall, they don't call the police. They don't want to get involved. They don't want to be questioned by the police. They don't want their neighbor to know that they called the police. So, unfortunately, it is common for people just to turn a blind eye.
I guess when you hear things like that, it's really sad. You understand on one hand, but then on the other hand, you think, man, maybe they could have potentially, not even in this case, but in any other case, maybe they could have saved a life. I mean, what would you recommend just as an attorney if a person does hear something like this or they hear anything of the nature and it seems like someone's scared? What would you suggest to them?
Call the police because, think about it, based on common sense, we know something is wrong when we hear it. I mean, we do. Yes, you might hear some muffling over on the other side of the wall that you really don't know what's going on. Okay, that's one thing. But when you hear a statement that common sense would tell you somebody is in distress or about to become in distress, sure, call the police. I mean, what's the harm? If you call it and the police come and they investigate and they go in and everybody's fine, they say, okay, well, thanks for calling and I'm glad everything's fine, and they go away. As opposed to the other situation would be you don't call and then something horrific happens.
If you were the suspect's attorney, how would you go about fighting this? Would you push for any lesser charges like manslaughter? What would you do?
You do basically three things, and that would be after you've seen all the evidence. You would have to wait until you get the evidence in this case. And that's called the discovery process. So as a defendant, you are entitled to all of the proffered evidence in the case. So you have to wait till that happens. And usually you could get a good feel of most of the evidence within the first 30 days, as long as the prosecutor is giving you the materials in an expeditious fashion, which many times they do. So first you got to get the evidence. Next, you got to look at, sure, is there any way, if the evidence looks pretty bad for your client, that you could get a lesser charge to try to show that, really this wasn't intent. It was more what's called a felony murder, meaning that there was no intent to kill, but there was an intent to do a felony, and unfortunately, a death happened. That's a lesser charge, or maybe a manslaughter. So you'd have to look at that. After that, what you have to look at is there some type of mental health defense? Now, like I said before, those are very rare. It's a high burden, but you still would have to examine that. And in the end, what you would also have to do, if all the cards are against you, like really there's no evidence that's helpful for you, you have to do damage control, meaning should your client plead out right now or try to plead out right now before there's an indictment which carries natural life. So that's what you would try to do in the end.
In your experience, how do juries respond to cases involving young female victims and just digital trails like this one?
Well, I think juries, for the most part, and I've done, I think I'm up to about 110 or 12 jury trials. Juries, for the most part, I think pay particular attention to physical evidence, scientific evidence, medical evidence, anything forensic. I think jurors are very interested in that. And, we understand why they are, because most people in society are. I mean, just look at our TV shows. They are loaded with different types of police shows, investigative movies where we see forensic evidence being used all the time. So I think jurors pay particular attention to that, especially when we get into the scientific areas. Like in cases that I've had where DNA is brought up, blood spatter, hair analysis, things like that, you will see jurors really pay attention to the experts testifying in the case, how they match DNA, how they match hair follicle samples, how they examine blood spatter to determine how was the victim hit, from what position, where did they fall, where did the blood go. It's very interesting sciences.
And one thing about this case in particular, which, a lot of cases are, just the emotional aspect, right? I mean, does the fact that Kayli was trying to set boundaries make this an even more emotional case in court?
Yes, unfortunately, people, I think for the most part, people in society are nice, and they try to do good things and they try to be good citizens. But unfortunately, you meet people along the way that don't respect that. So even though you're a nice person and you're trying to be kind to someone else by telling them, look, I'm not interested in you. I think you're a fine person, but I don't want you as a romantic partner. I don't want to become sexually active with you. That's a fine way of doing it because you're a nice person and you don't want to hurt someone. But sometimes you just meet the person on the other end that just doesn't respect that.
Given just the, I don't want to say popularity, but just given the how many people are talking about this case, right? A lot of people have heard about this case and how tragic it is. Could this trial be moved to a different jurisdiction due to pretrial publicity?
Again, highly unlikely. One of those situations where a defense attorney might make the motion, argue it in court, but the bar is pretty high to get a case moved. I mean, think of it this way. Minneapolis had the Chauvin trial. George Floyd was murdered and Chauvin was tried right here in Minneapolis, where there were riots and protests and, wired fences and cement barricades. And he didn't win a motion to move the trial. So it's pretty difficult to get a trial moved.
Yeah, that's a good point there. Well, we will be following this case very closely. Joe, thank you so much for coming on today.
Thank you for having me.
A GoFundMe for Kayli's family has raised more than $44,000. For Law and Crime, I'm Kennedi Walker.